one of the things I just heard this quote said recently, it's like a wise person thinks about their death. A fool just enjoys every day. And so it's morbid to think about your death, but we want to think about it so that number one, you're living your best life. And I heard people say you only live once. And it was funny because my nephew, when he was 6 years old, he goes, wrong. You only die once. And I'm like, oh, dude, good point. Right. So, like, just make sure you're living your best life. And then if anything happens to you, you want to make sure that your loved ones are taken care of. Right. And you're not putting a burden on them for the next year or 2 years trying to figure out, how to pay your mortgage. Where are your insurance policies? Did all your money, all your hard-earned money go to the government or did it go to your family? I know for me personally, 3 years ago, when I got mine reviewed with Rocco, the government was going to get a lot of money, right? And we got it all squared up. And now I know if something happens to me, my family's taken care of, which helps me sleep easier. And then the other part to think about, I had a coach do this exercise with me probably like 8 years ago. Has anybody ever done the ruler test of how old you are and how long you think you're going to live? Right. So, not that I hope I outlive this one, but I was saying 72, right? So, 72 inches is right here, and I'm going to be 53 in a month. This is how much time I got left on this ruler, right? When you see it physically, and here's how much I've already lived, right? So, there's not a lot of time left. So I want to make sure that my family's taken care of. And that's why we have Rocco on here today. So, Rocco, with that said, have at it, brother.
Well, I appreciate you having me on, Jeff. And one minute introduction. So my name's Rocco Cozza. I'm the founder and managing partner of Cozza Law Group. We are a business, estate planning, commercial litigation law firm, and I've been practicing law now, hate to say it, but over 2 decades. So I've had plenty of experience with what we're going to talk about today. And what Jeff was talking about is really looking at your life. And I have a picture in my office on my wall that says 3 words of inspiration: you will die. And it truly is meaning to live your best life. And I believe in that. And part of what we're going to talk about today, estate planning, I like to call legacy planning. It's really because when you think about planning for your death, no one likes to talk about it. No one likes to think about it. Our own mortality, we think we will live forever. But truly, it's about planning your legacy. What is the legacy you want to leave after you pass? What do you want your family? How do you want your family to be taken care of? Do you want your family to be burdened with certain decisions that they wouldn't have to make had you planned for it? The other thing I'd like to talk about just briefly about the whole legacy planning in general, this is not a set it and forget it thing. This is, I always say, a person's legacy or estate plan is living and breathing, meaning we're updating it every few years. As things change, you get married, divorced, have more kids, have assets, etc. We always want to look and fine tune things. As tax laws change, with the new administration coming in, there could be new tax laws that come into place. These are things we would need to look at. I know a lot of people on here are real estate agents or other professionals. So this is something to even be able to advise your clients about. So let's start with the basics, right? So I don't know how many of you on the call have an actual estate plan, but for those of you that don't know what an estate plan is, there's really 4 basic documents. So when you're a married couple, there's 8. So it's your living will. This is the document that says, when I die, this is where all my stuff goes. This is who gets it. Do I want to leave stuff to charity? Do I want my antique watch to go to my son? Do I want all my money to go to my spouse? That's document number 1. Second document is your living will. That is like your advance directive. When you are in a terminal condition, like end of life, you're not coming back. These are the decisions you want to make so your family doesn't have to make them. Do you want to be kept on life support? Do you want the plug pulled? Do you want hydration? Do you want to donate organs? These are decisions you're going to make ahead of time so your family's not burdened with that. Because think about that. If you don't have that document and you're in the hospital, dying in essence, do you want your child or your loved one or your significant other to have to make that decision to pull the plug? It's a burdensome thing. This document prevents them from having to do that. Then there's the durable power of attorney, which is the document that allows someone to manage your finances, access your bank accounts, manage your digital assets. If you're a business owner or have any type of business and you don't have this power of attorney and something happens to you, you're in the hospital in a coma, out of commission and someone does not have power of attorney, who's going to make your payroll for you? Who's going to write your paychecks? Who's going to pay the bills? Your business has come to a screeching halt. The fourth document is your healthcare power of attorney. This is the one that allows somebody, you appoint an agent to come in if you're in the hospital and maybe you're incapacitated. They're going to be able to make those decisions for you with instructions within that document as to what you want. So that's kind of the basic estate plan. So I tell people, if you are married, have children, have any significant assets, or buy a home, you should have an estate plan, because if you don't have those documents in place and something happens, either you go into the hospital, then the hospital and the doctors are going to decide what happens. If you die, the state decides what happens to your assets. And do you really want that to happen? In Pennsylvania, there's called, if you don't have a will when you die, it's called intestate succession. There are laws on the books that say, here's who gets the stuff. So if you're a married couple and have a kid, if you don't have a will, your spouse only gets 1/3 of your assets. Your kids would get the other 2/3, depending on how it's divvied up. So most people think that if I don't have a will, my spouse will just get everything. If you don't have property titled the right way, or the accounts titled it like payable on death or transfer on death accounts, your spouse is really only entitled to 1/3 under the state's intestate laws. That's why this is so important to have. And when it comes to real estate, I'm assuming a lot of you on this call are probably real estate agents or in that business. How you title property is extremely important. And in Pennsylvania, there's 3 ways to title a property. So if you buy a house, your first home, if you're a single person, you own it by yourself. If you're, in a relationship, so maybe you're not married yet, but two people, boyfriend, girlfriend, just significant others, they buy a home together. You own it in what's called tenants in common, meaning you each own a 1/2 interest in the house. If you own it that way, you don't know how to title the deed otherwise, and it's titled as tenants in common, which is a common error people make. One of the spouses could sell, or one of the significant other in that situation could sell their 1/2 interest without you having to do anything with yours. So meaning if you're in a relationship, non-married, don't own it as joint tenants, one party gets angry at the other, they want to move out, they can sell their 1/2 interest. You don't see it happen very often, but it's possible. The common way to title property when it comes to joint couples is joint tenancy with the right of survivorship. What that means is you own the property together. When the first person passes, the house automatically reverts to the other person. So it doesn't go through the probate process. You don't have to go to court when you die, probate the will, and then the property just automatically transfers to the surviving person. When you're married in Pennsylvania, there's what's called tenants by the entirety. It's the same concept of joint tenants with the right of survivorship, but there are some creditor protections with that. So that's when it comes to titling property, that's an important piece to understand. I know that people don't talk about it a lot, and you just assume the attorney's going to know what to do, but you really want to understand if you're going to own property with another person, you want to make sure it is joint tenants with a right of survivorship. That is an extremely important piece because it avoids probate. The cost of probate, it's an absolute must in my opinion. The other way you can own property is in a trust. Now, I can't tell you how many calls I get every week about people wanting to set up a trust. There are absolute reasons to set up a trust, and there are reasons you shouldn't set up a trust. So I don't know on the call how many people know the different types of trust, but there's really 2 major types. Revocable, which is a living trust, or irrevocable, which is a trust basically you can't change once it's set up. When you're owning property, if you're going to own property like a house or an investment property that's not in an LLC, if you're going to own it in a trust, you want it to be owned in a living trust. The only time you would put it into an irrevocable trust if you're doing Medicare or long-term planning. Because what that does is that takes it outside the estate, it protects it from creditors. A living trust is really just an alter ego of yourself. We're going to create this thing that we're going to put all of our stuff into, our house, our bank accounts, our investment accounts that are non-qualified assets, meaning non-retirement accounts. So when you pass, it doesn't go through probate. So meaning you don't have to go to court and have the court, distribute the assets. The trust stays in existence. There's a trustee appointed that manages that money. You still pay inheritance tax, but it avoids the probate process. Now, what people, there's a lot of stuff online about everybody needs a trust. I don't believe that theory. Pennsylvania's probate process is not very burdensome. Pennsylvania's laws are pretty terrible in most instances. The probate process isn't that terrible. So I've had people call that have a checking account and maybe a car and they want to set up a trust. Doesn't make sense. If you have substantial assets, meaning homes or non-qualified funds, meaning non-retirement account assets, and you want people to get those access to those immediately, it makes sense to have a trust. If you truly just have a personal residence and no other assets, spending the thousands of dollars to set up a trust and then go through the process of redeeding everything and managing the trust doesn't always make sense. So that's something that's very important to understand when it comes to living trusts. Irrevocable trusts, those are trusts that basically once you set it up, you can't change it. You have to appoint a third person to be the trustee. You're still the beneficiary, but you still benefit from all the money, from the income if you have rental properties in there or investment accounts, but you can't change it. You have to actually go to court for the court to allow you to make any changes to the trust. The reason why that is set up is it gives you creditor protection. You'll see a lot of people as they get older in age that have substantial assets, they'll set up this type of trust to avoid, Medicare look back. So if you go into a, state-run home and they come, Medicare, Medicaid comes back at you for the fee they paid on your behalf. If stuff is within this type of trust, of irrevocable trust, and it's past that 5-year look back period, they can't touch those assets. So it's a way to protect your assets. The problem when it comes to property is it deals with the step up basis. So when you buy a piece of real estate, say you're a husband and wife, you buy a home for 200 grand. You've owned it now for 30 years. The house is now worth $1 million. When one spouse dies, the second spouse gets what's called a step up basis in that one half. So meaning each party, if you bought it for 200 grand, your basis in the property is 100,000 each. If spouse one dies, they get what's called the stepped up basis. So now the house is worth $1 million at the time of death. Their one half interest is worth 500,000. So spouse number two basis in the property is their 100,000 plus the 500,000. So if they sold it and they had a capital gains tax, like it went past the 2-year period, they'd only pay capital gains tax on 400,000. If you put it into a living trust, same thing happens. You can even craft it in a way where that step up basis becomes the full step up to $1 million. If you put it into an irrevocable trust, like for Medicare planning or something, you don't get the step up basis. That's the math you have to do as you own property as you get older. If you're going to put property into a trust, like an irrevocable trust to do this long-term care planning, you have to look at, yes, it avoids inheritance tax because it falls outside the estate, but you'll pay capital gains tax. So if you have a house where, same example, you bought it for 200 grand, it's worth $1 million, and you put it into this irrevocable trust and your beneficiary is going to sell it at the time of death, they're going to pay capital gains tax on $800,000. If they put, so which you say take 20%, that's a big amount of money. If you put it into just a living trust, which is revocable, they would pay inheritance tax on the $1 million, but they wouldn't pay the capital gains. And inheritance tax in PA for lineal descendants is 4.5%. So it's a big tax difference, a huge tax difference. So this is kind of the math you have. That's why estate planning and legacy planning is not as simple as going online and getting a will. Like I've had people do that. I've had people go and find something online and yeah, okay, if you're going on a trip like tomorrow and you want to have something in place, that would work. But if you truly have any level of assets, children, you want to make sure that estate plan is actually thought through. Who's going to be the guardian of your kids? Who's going to control the money? These are all the extremely, extremely important questions you have to ask when it comes to planning. And it's not just like I said, one and done, because your situation is going to change. Say you put this estate plan in place, 3 years down the road, you get divorced. And now you have minor kids. Now you want to redraft that plan and look at, okay, with your ex-spouse, who's going to be the guardian of the kids? If you kind of have to now work with this party that you were married to, no longer married to make sure your estate plans, even though they're separate, talk to each other, because you don't want the courts to fight over who's going to be the guardian of the kids, who's going to be the trustee of the money for the kids if they're minors. There's a lot of things to the estate planning process. And I mean, we can get into very intricate details. I don't want to get, I know we're coming up to the 20-minute mark, so I don't want to get into too much like or niche details. That's what I'm here for, questions. You can always reach out to me. But that whole process. So when you're doing an estate plan, we always tell people it's a 3 to 4 week process. So you have to think about everything you own, who you want to control it, who you want to have it when you die, who you want to make decisions for you. These are things, so if you don't have an estate plan, you want to start thinking about those things. Who do you want to be your power of attorney? Is it your significant other? If something happens to your significant other, who do you want the backup to be? Who do you want to be the executor of your will? Meaning they're the ones going to go to court and make sure your wishes are, fulfilled. These are all these questions you have. It sounds like a lot, and it can be, but if you don't do it now, you're going to leave that burden with your family and your kids, and they're going to be fighting over it. And I can't tell you how many people come to us to set up an estate plan in their late 50s to early 60s because they witnessed a friend or a family member go through the estate administration process that did not have a will. And they saw how messy it is. Because in Pennsylvania, you have 9 months to do the estate and to file the final inheritance tax return and the estate tax return. That's not a lot of time when you think about it. If someone passes, there's going to be a grieving period. The more of these decisions you can make ahead of time and set forth in these documents, the easier it is on your family. We work with clients on the estate administration side, and truly, when someone has a well put together estate plan, it's very simple to manage. The costs stay low. It gets expensive to administer an estate when their estate's in shambles. They have nothing, or they haven't updated it. I updated a will for a client 2 weeks ago that hasn't been updated since 1995. So think about that. That's 30 years that they've had a will in place that luckily nothing happened, but we had to completely redraft it because none of it applied anymore. The people they had listed actually had died. Their backup executor and one of the trustees for one of their trusts they were setting up, this family trust, they were no longer alive. So then the court would have to appoint this. These are the things that the horror stories that happen when it comes to this stuff. And it's truly, it's one of, if not the most important decision you'll make in your life, putting together this estate plan. But it's really building and creating your legacy and taking that burden off your family and allowing your wishes to be fulfilled now and putting it on paper. And then you have an attorney that you're working with to really understand what your wishes are. They'll make sure that those wishes are fulfilled based upon those documents and who they're working with when you would pass. Couple last things I would say when you're thinking about an estate plan. Many people worry about the costs of that. And this is just every firm charges differently. We always try and do our things on a flat fee basis. So it's like, this is what you pay. If it takes me 50 hours to put it together, my job is to give you peace of mind and to make sure it's put together the right way. There's no hourly charges. It's just, if we have to sit here 10 times and go through that, that's for me to do. So I always want to make sure that clients understand that it's not, you get what you pay for. So if you go on LegalZoom and get a will, that's the kind of estate you're going to have when you pass, and you're going to have your kids, dealing with the LegalZoom estate administration, which is not something you want. So I'm not saying work with a professional, I'm not saying us, just any professional that does this. And you got to understand that it's not something that's going to be cheap, but it's going to save the better you do it from the beginning, the less expensive it is on your kids and on your estate when they go to administer the estate. I don't know if I saw a question pop up, Jeff, or something.
Some of the AI chats are
Okay, got it.
getting the
Okay.
checks out, but there was a question though.
Yeah.
Well, the first thing I want to say is you mentioned it, and one of the things I love about working with you, and
Yeah.
and having you be, I would say, like, not that I own you, but my attorney,
Yeah,
right?
absolutely.
Is that
You
the
owe me,
one thing
Jeff.
you just
That's why I'm
said?
here.
You go, Jeff, I'm here to give you peace of mind,
Exactly. Yes.
right? Which Rocco, every time I think about something legal, I go, oh
Yeah.
man, I'm good.
Yeah.
Rocco's my man. Like Rocco's in my corner.
Appreciate that.
And so my mom, who's 88 years old, right?
Yeah. Hmm.
And she never, literally just 2 years ago, when we sat with you, she put
Yeah.
hers
Yep.
together.
Hmm.
And right. And so when me and my siblings sat down at the table, we said, Mom, what are your wishes? And my one sister goes, it's obvious. Here's what she's going to do. And my mom
Yeah.
like looked at me and she goes, that's not what I want to do.
Right.
Right. So like,
Right.
can you imagine that fight? I have three older sisters. I'm 0 for 1,000 against one of them. Like, I don't want to have that fight again,
Right.
especially as a
No.
grown man. Right. So like,
Exactly.
so we sat down at the table and ironed it out for what my
Yeah.
mother's wishes were, right? And then we
Right.
sit down with you, you
Hmm.
put it in writing. It was a
Yeah.
super simple process, and
Yeah.
and I love it. And now my mom's wishes, and then there's no
Yeah.
fighting whenever my
Yes.
mom passes away, right?
That's what it does. It really truly, because that's what happens in these types of situations, right? Everybody thinks they want or they know what their parents want. It, I'll give you the flip side, like business, like if you own a business, right? That's a whole level of complexity you have to add to this estate plan. What's going to happen to your business? Do you have partners, et cetera? But a lot of times I see with the aging population, people that own a business, they think their kids are just going to take it over. 90% of the situation we've dealt with for the past 2 years, the kids did not want anything to do with the business. So a parent gets to the end, they're in their 60s, like, yeah, the kids are gonna take my business. You sit down and have that conversation. The kid says, I don't want anything to do with this business. This has been a burden my entire life. So then that changes the whole planning landscape. So these are the things you have to think about. Don't ever make assumptions when it
Right,
comes to your parents, when it comes to your kids. And I tell people when we have our initial talk and we give you our intake form, I say, sit down with your family and talk to them. Make sure that they understand that, hey, I'm appointing you as the executor. This is what it means. That means when I pass, you're going to be the one going to court, working with the attorney to do all this. Can you handle that? Are you willing to handle that? Don't just dump things on people. Make sure the people that are being appointed in these documents know what they're in for and are okay with it. That
right.
eliminates so many problems.
There was one question. Number one, are you taking on any new clients?
Yeah, yeah, absolutely. Yeah, we always do. Absolutely. We're
And
always happy to
then
help. Even if we can't help, I'll still chat with you and see if it's something, we have a referral for, but absolutely.
and then do you have a standardized price list, or is that something you discuss one-on-one with the person?
Yeah, I mean,
Because
so the base or the basic statement I'll give you. So if it's a single person, we for the basic for the will, the living will, the two powers of attorney. Single person's 1250, a married couple's 2500. Trusts are a little bit more expensive depending on the type, but that 2500 for a married couple gets you the entire estate plan you need. That's our initial meeting. That's answering any question you have, taking as long as it takes, coming and signing everything. And then when we do the process, we give you an original set, and then we also keep an original set here, like wet signatures in case something would happen. Because we've had people had fires and their estate plans went up in smoke. We always have an original set here. So yeah, that's kind of our base price for that. Typically, then we also started offering this year. We're actually starting to market it next month, like an estate plan insurance plan, where if you pay $99 a year, any updates you need to make to that plan, we don't charge for. Any
wow,
questions you have, call me up, we'll answer those questions. So it's really because we want people to understand that this isn't something you should stick in your safe and forget about.
right.
It's something if you're paying $99 a year, it's a small cost to keep it top of mind. And then when things happen, you'll know to call us and we'll make those changes. So you're not left where, I've had people that they got remarried and they had an old estate plan. And it's like, well,
Yeah,
shit, my ex-spouse is getting all the money.
yep.
And you got
And
to make sure that doesn't happen.
that cost, I mean, like on the surface, somebody said, hey, kick up 1,250 or,
Yeah.
1,250 bucks. You're like, whoa. But literally, when you think about what you're leaving, like if
Yes.
you don't do that, you're stepping over dollars to pick up pennies, right? Ignoring
100%.
it.
Yes.
And then instead of your
Yes.
family getting it, the state gets it, or
Yep.
the time lost trying to figure out what to do afterwards is going to be way more than that anyways. And for
Yeah.
me personally, it put my mind at ease. It was a no-brainer. And then when I looked at the burden that I
Yeah.
was putting on my family because I had the wrong beneficiaries. Like I had the wrong things going to the wrong people. I actually had it like almost exactly backwards.
Right.
Like what was going to my
It
wife
happens
versus
more
what was
often than
going to my
not.
kids. And I'm like, I
Yeah.
had no idea. So like all that gets straightened out and then more money's going to the family. The
Yeah.
other question was thinking about my mom. who owns
Yeah.
a home. What is the
Mhm.
downside of putting her home in the names of her children who will ultimately inherit it?
You won't benefit from the step up basis. That's a great question. That's a common question we get. So using the same example, say your mom bought the house for 100 grand and it's now worth 500 grand. If she puts your names on it now, you inherit the basis, meaning when your mom passes and you go to sell the house, say the next day, and you sell it for 500,000, you're going to pay capital gains tax on the $400,000 difference. If you let it pass through a will or through a living trust, you get the step up basis in the house, meaning your basis is the fair market value at death, 500,000. So if you sell it for that same price, you pay no capital gains tax.
Wow.
Never put your, I tell everybody, there has never been a compelling reason in my 20 plus years of practicing law to put a child's name on a house. Unless it's like they just bought the house and there's no real increase in value and they're hey, we're at the end of life. We know we're going to go in the next 5 years. We're not going to see a huge price appreciation. But if it's like a family home that was bought 20, 30 years ago, it's never a smart decision to do that because you'll pay way more in capital gains tax.
So Rocco, I think you just said I made a major mistake, right?
Okay.
So let me walk you through this. My mother bought
Yeah.
her house for $8,000 in 1970.
Okay.
Okay. In 2011, I sat down with my siblings at the table
Hmm.
and all of us moved back with my mom, with kids, some with spouses. So
Yep.
like she took care of all of us, right?
Okay.
And then she was at a point where she couldn't refinance or go on a reverse mortgage because she owed too much because of all the debt she ran up, the kids ran up.
Okay.
Okay. So I sat around, I said, listen, we can't put her on a reverse, but we got to help her because she wants to stay here. She doesn't want to go to assisted living and she's
Hmm.
totally healthy. So we refinanced and put me on the mortgage with her.
Okay.
And now everybody kicks in a little bit every month to help my mom not pay the mortgage, right? So she doesn't pay the mortgage.
Okay.
But now I'm on the loan and the
Yeah.
title with her since 2011. What impact is
Okay.
that?
So that's a good question. So it depends on, is it titled as tenants in common or joint right of survivorship?
I'm ashamed to say I don't even know.
That because that's going to be because then if it's titled as joint tenants, I mean, I'd have to look at it and see how many
Yeah.
people are on it and what's the fair market value of it today. But there's going to be a tax impact, definitely. You're going to have a tax impact instead of just letting it pass at death. But again, that's a situation where maybe that had to happen because you were helping your mom out. You needed to get this mortgage. And look, there are situations like that that are always just going to be the status quo, and you have to do it that way. I always say if you can avoid doing that, it's always best to avoid it because you're going to pay such a huge tax bill.
Okay. Any other questions? Anybody else want to unmute and ask Rocco any questions? If not, I got one more.
Yeah.
So when people are buying investment properties,
Okay.
is it better for them to put it in their personal name or an LLC name? Or if they're going to buy many properties, should they stack them all in one LLC or should they create LLCs for each different property?
So, couple parts of that answer. So,
Yeah.
you should, I believe, and again, some lawyers have differing opinions. I always believe owning your rental properties, investment property in an LLC for the liability protection. It protects your personal assets from the liability of the property. As far as how to structure them, different theories. Like I owned rental properties myself. I've done it since I was in law school. I always had in my head, I would put only so much value in an LLC. So that could be one property, or if I had, three terrible properties in McKees Rocks that were up to like 200 grand in value, I may put all three of those in there. I know other
Mm.
investors that they use one LLC per property, but it really depends on, that's when we talk to clients. I will never just sell someone a product. I want to understand, like, what are you trying to do now in 10 years from now? And what's the exit plan? Because then we have to kind of reverse engineer the plan and the structure. So LLC always, again, that changes lending. I'm assuming right, you're now in commercial lending. Um, what I also tell people, if you own a property that you're converting
Oh,
to a rental, to transfer to an LLC, you pay transfer tax. So sometimes it doesn't make sense to do that. Just get a really good insurance policy. But if you're buying it new, I would always put it in an LLC. That's my theory, always.
so there's a new rule that just came out with Fannie Mae not long ago.
Okay.
And I just saw this the other day and we talked about it on the team. So when you get an LLC, you got to get a commercial loan, which is a
Yeah.
shorter term, like 15 to
Yep.
20-year amortization and a higher interest rate, and it's going to
Hmm.
be variable
Yep.
versus a residential loan that we do that's a 30-year fixed rate at a
Yeah.
lower interest rate, right? Well,
Yep.
Fannie Mae came out recently and said that you can buy it in your individual name on
Hmm.
that 30-year fixed rate mortgage as an investment property.
Hmm.
You can transfer it to the LLC as long as you're the ownership stays the same. So if I buy it solo, I got to be the solo owner of the LLC, and
Okay.
they're not going to exercise the due on demand clause,
Okay.
right?
Which, yeah, great. But in Pennsylvania, you're other states that may be awesome because other states don't charge transfer tax. PA, if you own the property in your name and transfer it to an LLC that's even a sole member LLC, you're still going to pay transfer tax.
And that was the question we had.
Yeah.
And I thought we came up with the answer that we weren't paying that. Corey, Beetle, or KP. Or did we say you had to pay the transfer stamps or no? I thought we said no. Corey Ward?
Yeah, I actually had that question for another real estate attorney, and he said as long as the owners of the property and you were moving it into an LLC that had the same ownership, that there was no liability. But again, that's
No
just
transfer
In
stamps?
no transfer stamps. But
in
Okay.
Pennsylvania or just in
PA,
general?
PA.
I mean,
He's a
we
PA.
just did one last week and we paid the transfer tax on it. So I don't know if the law
Okay.
changed or something. So it's again, and I'm curious why he gave that answer because again, we literally did one last week to pay the transfer tax on.
Yeah, because we actually had to run a property that we bought personally, and then it was the first one between me and a friend.
Okay.
And we had the question at the closing,
Yeah.
because we wanted to set up an LLC, like you said, for
Mhm.
liability purposes, and we wanted to know if that, I'd assume that, if you transferred it, you would have to, but
Yeah.
I remember, him saying, which I thought was great, but again, it looks like that there's, that could be wrong. So,
How do
Yeah.
we
No, and
validate
I'll
that?
look into that.
Yeah,
Definitely.
yeah,
I'm curious.
yeah,
okay. Yeah, because it wasn't even like a title company who actually does real estate law. So
Okay.
again, I don't know.
No, no, I understand.
I'm
No, I
not,
mean,
that's not my lane for sure.
no, I
So,
completely understand.
yep.
yeah.
But
I would
again, I mean,
love to know that
laws could
answer. Yeah.
change. Yeah,
Yeah, because
I'll take a look into
that's
that.
a big thing. So,
Yeah.
Okay.
And Jeff, if I find the answer, I'll send it over to you and you can send it out to the group.
Yeah,
Absolutely.
yeah. We always send a recap out.
Yeah.
Um, and then we'll send out your contact information,
Yeah,
Rocco,
absolutely. Yeah.
with the recap. Any other questions for Rocco while we're here?
I sort of have a silly question. Well, I don't know if it's a silly question or not, but I'm going to ask it.
Yeah.
Um, so let's say, for example, like my aunt
Hmm.
notified me that I, at some point, would be the executrix of her will, which I don't
Okay.
want. I don't want that.
Okay.
God forbid something happens to my dad. Let's say, for example, and she has sisters and a brother.
Hmm.
Let's say, for example, her wishes are to not give anybody anything on that side. But
Okay.
for the sake of me wanting peace in the family, because I know what would happen,
Hmm.
would I be permitted to?
I know what you're asking. It's a good question. And it's a common question.
Yeah.
It would depend on how the will's drafted, to be honest with you. If she specifically disinherited them or specifically mentioned that they're not to get anything, then the court would not allow it. If it was basic language in there, it's not gonna be your decision, right? It's gonna be the court. So you could say I tried. If it's gonna cause, like uh,
Major
emotional
issue.
stress, then you rely on the court to make that decision because the court is going to follow what the will says. And if the will specifically disinherits people or says that they're not to get anything, then you couldn't do something. That's her wishes. You could not. They could if they filed a will contest. Like there can be language in a will as well, where if a party contests the will, they're automatically disinherited. So I'd have to look at the will to see what it says, but because this happens a lot, and I completely understand the emotional turmoil it would give somebody always in that situation. If you put yourself in that position, there's a couple things you could do. One, you can say, I don't want to be the executor. You don't have to be it. You can say, I refuse to be it. I remove myself, and the court will appoint one. Then it's not on you at all. Or you can say, the court, I can't change the will. You don't have the power to do that. Because if the executor had the power to do that,
Oh
there'd be
yeah.
no point in having a will. Does that make sense?
No, it does. It does. So, like,
Yeah.
once it's in your bank account, can I just like write the check and be like, peace, here you go. Here's everybody's
Yeah,
money.
I mean, and that has happened too, where
Yeah.
people have done that. Where once it comes out of the estate and to the beneficiaries, it's your money to do whatever you want with. The inheritance tax is going to be paid, through the estate for the inheritance tax return. Then it's on you to make that decision. You absolutely can do that.
Yeah.
And again, that's something, I mean, I'm happy to always, if you ever had a copy, well, I'd be happy to look at it for you and just kind of tell you what it says. I mean, feel free to send it over or reach out to me. Happy to.
Thank you.
Yeah, of course.
Good stuff. Any other questions? Anybody else?
Rocco, it's Matt Simpson. I got a
Yeah.
quick one for you. So
Yeah.
you mentioned very well, it's kind of hard to predict what any administration or
Right.
even like future tax law is going to be.
Yes.
So it almost feels like depending on how the will's written, you gotta change it it seems like every week nowadays. But I had when my wife, and also when you factor into that, hopefully I'm blessed to live a long time.
Right.
My child's financial situation when I pass might be
Mhm.
different.
Yep.
And it might make more sense for maybe them not to take it, but my grandkids to take it or
Mm-hmm.
something. So who we had worked with originally to form our will had what was called like a cascading rule in there to, I
Okay.
think, like whoever, like how there was decisions that could be made so that I
Okay.
didn't have to predict that my kids would equally take it. One of them could choose to take it and the other one could, based on their tax situation or whatever's going on, could give it to my grandkids. Do you guys incorporate anything like that? Have you heard of that
That's part of
before?
that's part of the plan. It's like generation skipping. You're trying to do a generation skipping tax. So it's really, you're saying if I'm given this, it can bypass me and can go to my descendants.
Yeah, to
Yeah,
give them
typically
the
you do
option
that.
at that time, Rocco. You know what I mean?
Yeah, you can put language in there. Again, wills can be, and then you can do it through a trust as well. And it's really, how long ago did you have it drafted?
Oof. Let me see. My oldest is 12, so it was about 11 years ago.
Okay, so it was probably right around, because there was some tax law that changed in 2014 with like they used to use things called AB trusts, which allowed the estate tax, but you don't need them anymore because the law changed. So that could be why they did something like that. But yeah, you can put language in there like, hey, it's basically a per stirpes distribution. So per stirpes means like it goes to my three kids. If one of these kids predeceases me, it goes to their lineage. Per capita means, hey, if I have three kids and one of them passes, the other two get everything, and that person's kids are cut out. Per stirpes distribution is a normal thing, and then you could also put language in there that I can disclaim that gift,
Mhm.
and it can go to my kids. You can definitely do it, and that comes down to the different tax questions in the tax situation at that time. But it can be a at the time decision, absolutely.
Perfect. Yeah, and that's what we were looking for. At least that's what we were told at that time, is we wanted
Okay.
to enable them to make that decision that was best for them instead of me trying to predict it at any
Right.
time. So,
No, understand. That makes sense completely.
okay, awesome. Thank you.
No problem.
And Chick has a question. Go ahead, Chick.
Hey Rocco, this is a chick from Bridge Insurance. I just have a quick question for
Yeah.
my wife's parents. They own a nice little house and everything, probably worth maybe mid fours. And when they pass, they want to give that house to me and my wife at what they paid for it, like around I think $100 and some $1,000. She has 4 other siblings as well too. Is that something that would fly? And how would
So
that work?
meaning when you say she wants to give it to you, mean sell it to you at that price?
Yeah, sell it to at that price, whatever price they pay. We'll just say like 150,000. So we would
Okay.
buy that house for 150,000, and that 150,000 would get distributed between the other siblings that we pay instead of giving them 450,000 divided by 4. Is that's
Yeah.
possible to do that?
Yeah, you'd have to be clear language in the will that upon death, the first part that would happen is you, but you'd have to be obligated to buy the house now, and that's
Right, right. Yeah, and we do. It's a nice house. It's a house for older people, one level.
Okay.
So
Yeah,
yeah,
you
it's
could
a
put the
house that
language
we
in there
want.
that's paid into the estate, that you purchase it from the estate, and then the remaining residual estate, once the sale of the house is complete, goes to the remaining 2 siblings.
And then what
It's just
about that?
carefully drafting it.
No, what about that capital gains part of it?
Well, if you're buying it for 150, that's going to be your basis. If you inherited it, you would get the stepped up basis. But again, then you'd have to almost have a separate agreement where you'd be willing to give the other siblings X amount of money. Because if the only asset is the house and they gifted it to you, you could get the step up basis, but then she'd have to rely on or have faith in the two of you to pay the other siblings the balances they would be owed had it went the other way.
And we could do a contract on that we have to do that, right?
You can, but again, it depends on how the mother looks at it. I've had clients that are
Yeah.
okay with that. Other people are like, I don't know what's going to happen. I want it in the will.
I'm trying to get her parents to come to you because I keep telling them about you and stuff. The dad's just super old school. He thinks he knows everything about his money and all that, but
Right.
I'm trying to
No,
get
I
you
understand.
here. All right,
No, I'm
thank,
always happy to just have a conversation with them too. Even if they don't use this, I'd be happy to just chat with them.
thank you, sir.
Yeah, of course.
Good deal. Any other questions?
Yeah, I have one. This is Kim
Yeah.
Davidovich. I recently got engaged at Christmas time.
Okay,
And
congrats.
I own my own house. Thank you.
Thanks.
And in Bethel Park, and he owns his own house in Irwin. I'm eventually in the next year going to move into his house, and we're either going to sell my house or we're going to use it as a rental property.
Okay.
So my question is, do I need to get my name put on his house, or can the will take care of that? Like if we do for married couple.
I would, once you're married, I would put the name on the house, unless you're going to have some sort of prenuptial agreement where these assets remain separate assets of yours. Once you're married, because it allows a right of survivorship, and when a married couple, when you own it as tenants by the entirety, it does give some level of creditor protection. So I would definitely have that put on there.
Okay.
Have your name put on there, unless truly you guys were going to look at doing a prenup where, hey, my house is mine, your house is yours. If we split up, we each take our own houses, and that's part of the prenup. But if you're not thinking about that, then I would have your name added to the deed.
Okay. Thanks.
Yeah, of course.
Great stuff. Any other questions? Rocco, thank you so much for your time, man. Like this is so
It's my
critical.
pleasure.
This is so important. And I feel like you had a huge impact on a lot of people here. And
I hope
so everyone that was on the call, thank you for spending the time with us. We'll get out the replay to you. Rocco's contact information will be on there. Reach out to him and have a great day.
Yeah. Awesome. Appreciate
Thank
everybody.
you.